Hello, this is Sarka Wilde from Visiting Property Consultants, and today I have here Kyle Wyness, who is Director and Head of Litigation at Spratt Endicott, based in Banbury. Hi, Kyle.
How are you doing, Sarka? Nice
Yes,
to see you.
good to see you too. Good to see you too. I'm always pleased to see you. However, I know that whenever I see you, it's usually for the reason that is not always a very good reason. So,
Very
uh,
true.
yeah. But thank you very much for your time today. That you agreed to come to speak to me. Because
No problem.
we've got pertinent topic to cover, and that's talking about evictions, something that nobody really likes to talk about, and but sadly it's a part and parcel of being a landlord, and sometimes we all know that landlords do not want to evict tenants. Every landlord wants a tenant who will stay in the property, look after it, and pay the rent. And that's the ideal outcome. But sometimes, through various situations in the tenant's life, tenants do default on the rent and they don't pay the rent, and sadly the landlord has to go through the eviction process. And we also know that if the tenant requires social housing, then the system is such that the tenant would not be offered social housing until they get evicted. And therefore, landlords need to be prepared that if such a scenario happens in their life of being landlord, they need to know what they need to do in order to evict successfully and gain the possession of
Yes.
successfully. So I'll just obviously ask you, Carl, if for the benefit of the listeners or people who watch our conversation, is what are the timescales? What are the processes? So would you run us through whole process?
Yeah.
From the beginning, beginning to the end. Just imagine that you are talking to somebody who never ever went through eviction ever before. That somebody who is completely new to it and happened to be in the situation where they need to evict.
Absolutely. Absolutely. Well, look, the first thing to say is that the good news is we're back to the pre-COVID position, because we went through all sorts of entertainment with actually evictions being prohibited at one point in time, and the notice periods that we had to use in the notices themselves, they were extended significantly, which caused all sorts of problems, really, in terms of backing up cases for the court and also for landlords as well. It was taking a very long time to evict tenants at all. And while I understand why the government did what they did, it probably pushed things, from my point of view, certainly a little bit too much in favour of the tenants over that period of time. But the good news is that we're back to the pre-COVID situation, where the situation is certainly a bit more straightforward than it was at that over that period. Now, basically, there are two types of eviction, and what I would suggest that I do is I go through the two different types. We sort of generalize them as being fault or no fault evictions, as you alluded to. With the fault evictions, what you have often, or more often than not, certainly in a lot of the cases that we deal with, it's when the tenant, for whatever reason, gets into financial difficulty. Perhaps they lose their job, perhaps they suffer from illness, something along those lines, where they're no longer able to pay the rent. And so for us, the rental arrears tend to be by far the biggest ground upon which landlords will look to get possession back, or have to get possession back. With the fault route, it basically involves, in the first instance, the service of what's called a Section 8 notice. It's a notice under Section 8 of the Housing Act 1988. And in that notice, what the landlord has to do is rely on one or more of the grounds that are set out in Schedule 2 of that Housing Act 1988. Now, the grounds are divided into those that are mandatory and those that are discretionary. the mandatory grounds are ideally what the landlord wants to be able to rely on, because if the landlord can make the ground out at the possession hearing, then the judge doesn't have a discretion, at least in theory anyway, doesn't have a discretion, has to make a possession order. If you're relying on discretionary grounds, then the issue is that the judge has to be persuaded that it's reasonable in all the circumstances for a possession order to be made. And that tends to be a bit more tricky, depending on which of the grounds that you use. When it comes to serving the Section 8 notice, depending on which grounds you're using, the notice period will differ. And the notice period can be anything from basically nothing at all. So in other words, once you've served the notice, you can start proceedings immediately. That is in the case of antisocial behaviour. And I can understand why that would be the case, because if you have really serious antisocial behaviour, we'd obviously want to be getting the matter off to court as soon as possible. For the rent arrears grounds, it's 2 weeks, and that's the case with a number of other grounds like breach of covenant. Then for pretty much all of the other grounds, it's 2 months. So from our point of view, we start off, as say, the process by serving that. If the tenant doesn't comply or doesn't remedy the breaches within the time frame and the notice expires, we then issue a standard possession claim at the court. The court will then issue a possession or list of possession hearing, I should say. That possession hearing will generally take place around 6 to 8 weeks from the date the claim is lodged at the court. Assuming we are then able to make out one or more of the grounds at the possession hearing, the judge will make a possession order. And usually the order that is made is that the tenant is required to give up possession within 14 days. If the tenant doesn't do so, then unfortunately the landlord can't still just go and change the locks. It's a case of then applying to the court for a warrant of possession to be issued so that a bailiff's eviction appointment can be scheduled. And it's during that eviction appointment that the tenant can be removed, using reasonable force if necessary, from the property. And at the moment, it very much depends on which court you're dealing with as to how quickly the eviction can be scheduled. I mean, Oxford, I have to say, is relatively efficient on that side of things, and you're probably looking at around 4 weeks from the date that you lodge the warrant at the court to getting the eviction appointment. Others down in London, for instance, can take up to 2 or 3 months, which is far from ideal, particularly when you have a scenario where you have rental arrears that are the big issue in that case. So, I mean, all in all, if everything goes really well and we get a possession order at the first hearing, and also there is no need to, or we then have to evict, you're probably realistically looking at around 14 weeks as a rough guide from lodging the claim at the court to getting physical possession of the property back. I should mention one other thing in terms of the date of the possession, the date of possession in the possession order. It is open to the tenant to ask the judge to extend or to use discretion to extend that 2-week period up to a maximum of 6 weeks. But the onus is on the tenant to demonstrate that they would suffer exceptional hardship if they were required to vacate the property within that sort of usual 2-week period. And exceptional hardship doesn't amount to things like, well, I haven't got anywhere else to go. It's more that perhaps the tenant has children who are doing an important exam or revising for exams. Maybe the tenant is disabled or perhaps has or suffering from an illness. It's something compelling which would encourage the judge, I suppose, for want of a better description, to actually go ahead and exercise that discretion up to the maximum of 6 weeks. So that's kind of the fault procedure, if you like. The no fault procedure, and well, we'll wait and see if that actually still remains in play at the end of this year, which we can discuss later on, Sarka. But at the moment, there is a no fault route, which involves the service of what's called a Section 21 notice. It's a notice under Section 21 of the Housing Act 1988. And the whole point of that being introduced was that it enabled landlords to get their tenants out or to evict tenants without actually having to have a particular ground or reason to do that. So in other words, we didn't have a situation where you had to show that they had rent arrears, that they perhaps breached the terms of the tenancy, that there was antisocial behaviour, something along those lines. And that, I have to say, has been a very useful tool for landlords because it has meant that they are pretty much guaranteed to get possession of the property back as long as they follow the correct processes and ensure that a valid Section 21 notice has been correctly served. So under the Section 21 procedure, say we serve the Section 21 notice, it has to give the tenant not less than 2 months' notice of the landlord's intention to bring the tenancy to an end. I should say that there's a common misconception here in that the Section 21 notice doesn't act like a notice to quit. It doesn't have the effect of bringing the tenancy to an end. All that it does is say to the tenant, at the end of this 2 months, if you haven't vacated, then I'm entitled as the landlord to go to the court and to obtain a possession order. So that's kind of the way it works. Now, the difference with Section 21 and Section 8 notices is that over the years, the government has introduced more and more legislation, which introduces more and more, well, I call them obstacles. I suppose they're probably obligations would be a better description, which landlords have to ensure that they are properly adhering to if they want to be able to serve a valid Section 21 notice in the first place. And you, Sarka, you'll be aware of a lot of this through the letting issues that you sort of deal with. But the basics, I suppose, from that point of view are, firstly, if the tenant pays a tenancy deposit, as most tenants will do at the start of the tenancy, then there is an obligation on the landlord to protect that deposit within one of the government tenancy deposit schemes. That has to be protected within 30 days, and if it's not done, then it can't be rectified. It is a sort of strict liability scenario. So it has to be protected within 30 days of it being received. In addition, the landlord has to send and serve to the tenant the prescribed information relating to the tenancy deposit scheme in which the tenancy deposit is protected. Again, that has to be done within that 30-day period. That one can be rectified at a later stage, but obviously it's firmly in the interests of the landlord to make sure that all of this is done within the 30-day time limit to begin with. Because if they don't do so, then it's open to the tenant to make an application to the court, A, for the return of the deposit, and B, for compensation, which is equivalent to anything between 1 and 3 times the amount of the deposit. And the problem is, if they haven't complied with that 30-day time limit, the landlord doesn't have a defence to the claim. They will end up having to pay compensation. So that's why it's very important to ensure that the deposit's protected and the prescribed information served. If it has done, then there's no problem with the Section 21 notice. The other elements which were introduced back in 2015 require the landlord to serve an energy performance certificate, an up-to-date gas safety record, and the government's how to rent checklist, as it's called, on the tenant at the start of the tenancy. Now, the case law is a bit sort of up and down on this, but generally speaking, if it's not done, I haven't come across a court yet which hasn't been prepared to make a possession order in the event that the matter is dealt with late, so the service of the EPC, gas safety record, etc., are dealt with perhaps not quite at the start of the tenancy, but obviously good practice is very much to ensure that you do just that. And with the gas safety record, obviously, if new tenancies are granted, then you want to be ensuring that you're serving up-to-date versions of that each year and getting annual services done. With the how-to-rent checklist, if new tenancies are granted, again, if there is a new version of the how-to-rent checklist that has come out in the meantime, that again will need to be served in conjunction with that new tenancy. The problem is, if this is not done, then any Section 21 notice you do serve will not be deemed valid, and therefore any possession claim you bring to the court will end up being thrown out because it invalidates the Section 21 notice to begin with. Now, there are other elements to it. Other things that have to be taken into account are things like whether or not the property itself has to be licensed, whether it's because it's in an area where mandatory licensing is in place, or whether it's a house in multiple occupation. Again, there are issues with the validity of Section 21 notice if that hasn't been done, and obviously any proof of the licensing requirements and the license itself has to be included with the claim form in the event that there is a license requirement. Assuming that we have complied with all of these obligations, at the end of the 2-month period, if the tenant doesn't get on, then it's open to the landlord to issue what's called an accelerated possession claim at the court. accelerated is probably not an apt description because it's not quick, but the whole point, I think, is that it is supposed to enable the court to deal with the application on paper and without the need for a possession hearing. And because of that, it's very much of a front-end loaded application that has to be made. And as a solicitor, when we're lodging the claim form at the court, which in itself is 20 pages long, we have to attach copies of the tenancy agreements, copies of the deposit certificate, detailing when the prescribed information was served. We have to enclose the EPC gas safety certificate, any license, the how to rent checklist. So, as I say, it's basically very much tailored so that, in theory at least, a judge should be able to make a possession order without having to take the matter to a hearing. Now, again, like the standard possession claim, assuming that the judge is happy that all of the paperwork is in order and that a valid Section 21 notice has been correctly served, then the usual order that is made is for the tenant to deliver possession within 14 days. But like with the Section 8 notice and the standard possession procedure, as we call it, again, the judge can use discretion to extend that up to 6 weeks if the tenant can demonstrate exceptional hardship. And Sarka, you mentioned about the local authority housing. This is an issue which we find more and more these days, that you may have a position where the landlord needs the property back for whatever reason. The tenant wants to go, but if the tenant is then reliant upon being rehoused by the local housing authority, they are being encouraged to stay and to force the landlord to evict them, because if they vacate voluntarily, then they're deemed to have made themselves voluntarily homeless. And in those circumstances, they end up towards the bottom of the housing list. Whereas if they end up in a situation where possession order is made, the council will treat them as a priority. And look, it's not an ideal scenario for landlords and tenants, but at the same time, I can understand why the councils have to do that. I mean, the position is that they have limited housing stock, and it's a question of how you allocate that. So it's what we have, and it's what we have to live with. But as again, assuming, sorry, go ahead.
Yeah, it's a little bit vicious circle, as you said, because obviously council has got limited stocks, the local authorities have got limited stock, and tenants are being advised what they are being advised, but that's that vicious circle that would probably make another webinar discussing about how government could actually support the private rental sector and landlords to actually keep the properties, because in recent years landlords have been punished by unnecessary taxation and everything. So there is shortage of the housing that is not being addressed very effectively. So it is really vicious circle. But also when you were talking obviously about having all the paperwork in a place, such as serving EPC, serving gas safety certificate, electrical safety certificate, all that. This is really important, and we obviously, I see it day in day out in our firm when we deal with lettings, and that's pretty much part and parcel of what we do when we are letting and managing properties for the clients. If a landlord, for example, if you had a landlord, because sometimes a lot of landlords who are managing themselves, I always say to people, if you manage yourself, you're really exposing yourself quite a lot, unless you are a landlord who studies legislation every day. Day in day out, you are really exposing yourself to self-managing, because often the legislation changes and landlords are not aware. If they don't have that paperwork in order, obviously they couldn't use a non-fault eviction, so they can't evict. They would only have to go the Section 8 route, wouldn't they? Providing that there are grounds for it.
Well, indeed, and that's the problem, isn't it? That this, yeah. I mean, until the whole assured shorthold regime was introduced, that was the problem which landlords had. They had to show one of the grounds in Schedule 2 of the Housing Act if they wanted to get possession of the property back. But that was giving way too much protection, I think, to tenants, because it was making it, well, I'd say virtually impossible, but certainly extremely difficult for landlords to get possession of property, particularly if it was a scenario like something that perhaps they wanted, they were in a position where they needed to sell the property. So yes, no, absolutely. But
so
yeah.
Kyle, obviously, we've touched a little bit the tenant Section 21 being abolished in near future. Do you have any for the listeners? Do you have any information about what this notice would be replaced with? Because obviously landlords may have situation where they may need to get the property back. They may need to live in it, or they may need to sell it. They may need to place a family relative in it. What is in store instead of Section 21?
Well, yes, that's the entertainment, isn't it? So the position is that there is a renters reform bill, which is going to be going through Parliament, or currently is going through Parliament. And this was created because the government decided that the private rented sector was not particularly fair on tenants. And really what they were suggesting, the main motivation behind it was trying to get a situation where tenants are encouraged and are able to take longer lettings. Because at the moment, you'll know that with assured short-term tenancies, often the tenancies are granted for 6 months or a year, something along those lines. It's probably more unusual than not to get anything longer than that. So the whole purpose of the bill is to put tenants in a situation where they feel they have a bit more security of tenure. Because at the moment, that's one of the big bugbears of tenants with Section 21, in that as long as we're outside a fixed term of a tenancy or coming to the end of it, a landlord can just serve a Section 21 notice, even if the tenant's, say, been in there for 14, 15 years, and doesn't have to provide any sort of ground upon which to get the property back. So the idea of the bill is to abolish Section 21 notices and to abolish the no-fault eviction route. What the proposal is at the moment is not to replace it specifically with another particular notice, but what is going to happen in all likelihood is that new grounds will be introduced into Schedule 2 of the Housing Act, which introduce different scenarios where landlords are able to get back their property. For instance, if they're wanting to sell the property, or if they are wanting to let it to a close family member, something along those lines. They're also going to be introducing new grounds where there have been serious and varying episodes of serious rental arrears, which I'm assuming will end up being a mandatory ground, so that actually, it's not just a situation which reflects the current arrears, but if there have been different situations over the subsistence of the tenancy, where arrears have been, a pretty bad feature, really. So we're yet to see exactly what new grounds are going to be introduced, but I think one of the other things is there is a suggestion that for the rent arrears grounds, the notice period of 2 weeks could well be extended to 4 weeks as well. But so while we will lose the no-fault eviction route, what I'm hopeful is that the government will ensure that there are scenarios covered which landlords will be able to, or grounds where landlords will be able to use grounds without necessarily having to particularly prove any breach of covenant on the part of the tenant, particularly when it comes to things like the landlord needing to sell the property or wanting to move back into the property, something along those lines. So, yeah, I mean, it is anticipated at this stage that we may well see the end of no-fault evictions by the end of this year, but that remains to be seen, and I suppose we'll just have to wait to see how quickly it goes through Parliament. I mean, my own view is that perhaps this is going to be a bit harsh on landlords, that much as I understand the reasoning behind it, the no-fault route, particularly because of the obligations that governments have continued to add to landlords to ensure that they can serve valid Section 21 notice, I think has been sufficient to ensure that the proper landlords, those that do the job properly and correctly, and ensure that they are really complying with the legislation. I think that has sort of separated the wheat from the chaff, in that regard. But as I say, it appears that the government has taken the view that it would be better to be giving tenants more security of tenure. So it remains to be seen really how that is going to work out in practical terms.
Yeah, it is going to be, I think harsh on the landlords from that perspective. Albeit, I do see the idea behind to give tenants a little bit more security, because as we both know, it is really important to have safe home,
Absolutely.
and if you are renting, you are still entitled to have safe home. With the prices of the housing, not people, less and less people can afford to buy, and
exactly.
The age, basically age level where people can afford to buy their first home is higher and higher. So from that perspective, I personally think that there are other things how to give tenants more security. I'm personally, I'm a great advocate of having always fixed terms for both landlord and the tenant, because both
Absolutely.
of them have got security, and obviously you can have assured short hold tenancy for up to 3 years, can't you? Because then anything above 3 years, you would have to have tenancy written done by deed, but below 3 years. So if somebody, for example, wanted 2 years tenancy, why not to have 2 years tenancy or assured short hold tenancy with maybe 1 month's break? 1 year break clause, or
exactly.
anything like that. And we always encourage towards the end of the fixed term to renew for another fixed term, providing both landlord and tenant want to renew.
We're happy to do it.
So there are ways, and I understand where the government is coming from, but perhaps it would be good to give it a different reconsideration in terms of what to do, rather than abolish Section 21. But then that would be again another discussion for another time. Really, we just need to work with.
We work with what we've got. Absolutely.
What we've got, yeah. I will ask last question before I wrap up, which is something that that obviously it's linked to the evictions that some our clients have experienced, and then obviously you described the timescales for eviction, but we know that in recent years those timescales were much longer, and then obviously when you get the possession and you have to apply for bailiffs, should the tenant not go, because often tenants don't go even when they have to vacate, and then you need to apply to the court for bailiff to attend. And we had some cases where we would wait about a year to get the possession, or landlord would wait. As you said, Oxford one, whenever we dealt with Oxford court, that was pretty straightforward. But on the default evictions, I suppose the question is here: is there anyhow landlords could protect themselves in this way? We personally, as an agent, I always suggest this to all managed landlord. We offer a rent protection service, so we've got one level of management service where we offer basically rent and legal protection service, because if you think how many months you are waiting for the possession and you are not being paid any rent, that can really dent not only your investment but savings, because often landlords, if they've got just one property or maybe two properties, those properties are their pension, and therefore they are not making a great deal after they paid all their expenses. So not getting paid rent for 1 year or 8 months is quite long time. Do you think, do you have any tips how could landlords, obviously, if they do not have the legal protection, how they can prepare themselves just in case that they would have to evict to make everything quite quick and smooth?
Absolutely. Well, firstly, making sure that all of the paperwork's in order. You know, that's the prime issue which we come across, primary issue we come across when it comes to potentially looking to evict tenants. And that's particularly so with the accelerated no fault possession route, opposed to the fault and rental arrears, that sort of situation. Look, it's a very difficult one because the problem is that landlords are limited in the amount of deposit that they're able to take. Obviously, deposits there to try and protect landlords somewhat, in relation to things like arrears that have arisen or damage that's been caused to the property. But really, it's a case of making sure that your ducks are very much in a row, so that if there are arrears, that it's all clearly set out in a schedule, so that we are ready to go straight away if we have to serve a Section 8 notice. From that point of view, you mentioned the rental warranties. Obviously, I think that those are offered quite a lot these days, and it's probably in the interest of most landlords to take those, because obviously they are designed to potentially, one, to deal with any eviction, and to also pay the landlord rent in the interim period. Because, as you say, when it was taking an inordinate amount of time to actually get possession back, it could be financial ruin to landlords. But other than that, the problem is that the process is the process. We have to. There are certain hoops that we have to jump through. There are no shortcuts. Much as I would love to be able to tell landlords that there are, the only way that we can legally evict tenants is to get the possession order from the court in the first place, and then, if necessary, take steps to enforce that. But really, it's just a case of making sure that the letting has been done correctly, that all of the paperwork is in order, and that all your record keeping is spot on.
Yeah, thank you. Well, thank you very much, Kyle. It's been a pleasure as always. Could you just let people, I will at the end of this recording, I will post your details, but can you tell people where they could find you should they wish to discuss with you any legal aspect of litigation, property litigation?
Absolutely. So, as Sarka said, I am a director and head of property litigation at Spratt Endicott, and we're based in Banbury, as well as having offices in Bicester and Brackley as well. If you want to contact me, not just for residential tenancy matters, but any sort of property litigation, my email address is kwyness@se-law.co.uk. You can get that on our website, or alternatively, my number is 01295 204135. More than happy to assist with any queries or concerns you have.
Thank you. So Kyle has shared information, and if anybody found interesting what Kyle was talking about, and you've got any queries, please do contact him on the details that he published. Thank you for listening, and bye for now.